Everyone have a good evening. Enjoy your day yesterday. Wonderful, wonderful. Welcome to the workshop. It's entitled Understanding Employment Rights and Disability Insurance, but you do that already. My name is Mark Spina. I'm your moderator today. We're looking forward to hearing this topic from our guest speaker. It's a very important topic. I know many of you are very interested to hear it. This session is interactive. It's split up into half presentation, and then the second half will have 30 minutes for questions. So please hold your questions till the end, but we will try to get everyone in. Please join me in welcoming Ms. Monica Fawzy Bryant.
Trying to give me a promotion here.
Yeah. Ms. Bryant is the Chief Operating Officer for Triage Cancer, a national nonprofit organization connecting people to cancer survivorship information. She's dedicated to improving access to quality information on the practical insurance and financial issues surrounding a cancer diagnosis. Previously, Ms. Bryant worked as Midwest Regional Director for a national disability rights organization. She was legislative counsel for U.S. Congresswoman Linda Sanchez and law clerk for U.S. Senator Dianne Feinstein. During her time in Congress, she focused on health, justice, civil rights, and women's issues. Ms. Bryant is now an adjunct law professor at John Marshall School of Law here in Chicago, teaching a class on cancer rights. Please, let's welcome Ms. Bryant.
Thank you very much, and thank you for getting up early and coming to hang out with me for a little bit. I hope you're all sufficiently caffeinated. All right, so I will just preface all of this with there are more slides in the deck than I'm actually going to talk about. And the reason is this is a really complex topic, and if you don't present it linearly, it's not good when I'm tongue-tied this early, it can be a little bit confusing. So if I skip through a slide, don't panic. It's there for you to read. It's there for reference. If you have questions, we can always go back. So have any of you ever tried to put together one of those 1,000-piece puzzles with, have any of you ever tried to do those? You have more patience than I do. Have you ever tried to do it without seeing the picture on the box? Oh, wow, we have an overachiever over here. That's kind of what it's like to go through this process and try to figure out how all of these laws and practical issues fit together. So I'm hoping that today I'm going to give you the whole picture and we can start to put together that puzzle together. So we're going to be talking about some federal laws, some state laws, and how the practical issues also come into play. There are a couple of different places where you can go to look for your rights in the employment arena. There are leave laws, both federal and state. There are fair employment laws. The federal Fair Employment Law is the Americans with Disabilities Act, and state fair employment laws. And then finally, if you work as an employee under a contract, so either just a regular employee contract or you're a member of a union, that contract also gives you rights and benefits. But the matter of the fact is that the law is the bare minimum of what employers have to provide. And many employers are much more generous than that bare minimum. And so it's really important to look to your specific employer or potential employer to see what rights and benefits they're providing. The place to do that is some sort of policy and procedures document or employee manual. Every employer is a little bit different in how they present this information, but the kinds of things you want to be looking for, what are the benefits? Health insurance, dental insurance. Are there short or long-term disability programs in place? What are the sick time rules? Does your employer have something like a pool where other employees can donate their paid time off that you could draw from if you've exhausted yours? And then finally, you'd want to look to see if they've laid out any processes for how to ask for things like medical leave or something called reasonable accommodations, which we'll get to. So very important not just to jump to what does the law entitle me to, but also to look at what your employer is providing. Which brings us to the first law I'm going to talk about, the ADA. Now, the ADA is an incredibly valuable tool. And when I talk about all of these laws, it's really important to remember that they are tools. So a lot of times people, especially at these kinds of conferences, say, oh, a lawyer's presenting, is she going to teach me how to sue my employer? We hope not. We hope it doesn't ever get to that point, because we want to give you again, tools to solve issues before it gets to that stage, and the ADA is one of those tools. So in order to be eligible to use the ADA's protections, there are a few hurdles that you have to jump. The first is that you have to work for a big enough employer. And that means a private employer with 15 or more employees, or a state or local government. If you work for the federal government, you do have similar protections, but it's actually under a law called the Rehabilitation Act. Very similar, but important to know. The second hurdle is that you have to be a qualified individual. And I've given you the legal definition of what that is, but basically it means you're qualified for the job we're talking about. If you're applying to be a brain surgeon, you've gone to medical school. If you're a commercial truck driver, you have a commercial driver's license. And then finally, you have a disability under the ADA's definition. Now, I will use the word disability in several contexts throughout the next 30 minutes. Please keep in mind that every time I use it, it has a slightly different definition. Under the ADA, a disability is a physical or mental impairment that substantially limits a major life activity. It's a mouthful, so let's break it down. A physical or mental impairment, that's usually the easiest thing for people to figure out. So, you've gone through treatment, and now as a result of treatment, you're having a very hard time concentrating, or you're having high levels of anxiety. That physical or mental impairment has to limit something called a major life activity. And I've given you some examples here, but what major life activities are is anything that someone in the general population can do with little or no difficulty. So again, these are just some examples. This is not an exhaustive list. And then finally, that limitation to a major life activity has to be substantial. So it can't be, every once in a while I have a hard time getting to sleep. But rather it's every single night I'm up till 5 o'clock in the morning because I just can't get to sleep. Now, once you've figured out that you're eligible to use the ADA's protections, there are 4 ways to use it. The first is that you currently have the disability. You're going through treatment right now, or you're currently dealing with whatever limitation it is. The second is that you have a history of having this disability. So you're several years out of treatment, but now you're being treated differently because of this knowledge of your history. The third is by being regarded as having a disability. And this really isn't about you or your abilities at all, but rather it's about somebody's perception of you. So maybe they found out that you've had a transplant, and they know somebody else who's had a transplant and had a horrible time with it. And now they're treating you differently because of this other person. And then finally, the fourth way is based on your association with a person with a disability. And this is where caregivers can get protections under the ADA. Now, the ADA applies to all phases of employment, which means that it applies even before you have a job. In the interviewing process, the ADA protects you if you're eligible. It also applies for things like promotions, benefits, firings, the entire phase. Now, we figured out if you're eligible or not. We figured out there's 4 ways to use the ADA. What does the ADA actually get you? In all of these instances, the ADA protects eligible individuals against discrimination. Now, discrimination isn't always negative. Sometimes employers might be treating you differently out of a really good place. So they might be thinking, well, I don't really want to give Bob this promotion because it comes with a lot of stress and a lot of long hours, and I know he's already gone through a lot, so instead I'm going to give the promotion to Jane. Even though it comes from a good place, it's still discrimination, and the ADA protects you from that. Now, for individuals that currently have a disability, they're also entitled to something called reasonable accommodations, which I'll get to in a moment. Now, for those of you who have had your caffeine this morning, you may be thinking, well, wait a minute, the ADA only applies to employers with 15 or more employees. So what happens to individuals who work for smaller businesses? Well, thankfully, every single state has a state fair employment law. Most of them are very similar to the ADA, but they can be more protective in a couple of different ways. And one of perhaps the most important ways they can be more protective is that they cover smaller employers. So this chart shows all the different states that have state fair employment laws that cover smaller employers. So if you look in the first column at Illinois, in Illinois you only need one employee for that employer to be covered by the state fair employment law. So as long as you don't work for yourself and discriminate against yourself, you're protected in Illinois. Now, if your state is not listed here, it's the same as the federal law, and it requires 15 employees. Now, one of the most common questions that we get in this arena is, do I have to tell my employer or my potential employer about my disability, or about my diagnosis, or about my transplant? And the answer is, generally, no, you don't. However, you might have to disclose some information about your medical condition if you want to access certain protections. So if you want to access the ADA's discrimination protections, you might have to disclose some information. The rationale is, if the employer doesn't know that you have a disability, how could they be discriminating against you based on your disability that they don't know you have? The second is to access these things called reasonable accommodations. And the third is to take medical leave. Now, I could spend 2 hours, and actually we do in some sessions, just talking about disclosure. But since we don't have that kind of time, I point you to a great webinar from one of our wonderful partners, Cancer and Careers. And frankly, I'm going to talk about them a few times because they have some really great resources in the area of work and cancer. But they have an entire hour-long webinar on this issue of disclosure. And while we're speaking about disclosure, I will say that I actually present this webinar as well, so you'll hear a familiar voice. So as promised, let's talk a little bit about this thing called reasonable accommodations. What are they? The legal definition is any change in the work environment or in the way that things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Now, complete mouthful, what are we actually talking about here? And let me give you some examples. We generally put these reasonable accommodations into 3 buckets. The first bucket is modifying your physical workspace. Our favorite example of this is a woman who, when she went to work, she was experiencing extreme nausea, and she couldn't figure out why it was just at work that she was having this problem. Lots of dissecting what was going on, and we figured out that her office was right next to the cafeteria. So all day long, she was smelling all of the smells out of the cafeteria. Well, her reasonable accommodation was switching offices with somebody to be the furthest away from the cafeteria. Similarly, one of your issues is fatigue, and your office is the furthest from the elevator. Maybe you can flip-flop. It could also be something as simple as not having neon lights in your workspace because that's bothering you. It could be about having equipment. So if you're fatigued and the office printer is like a mile away from where your desk is, maybe the accommodation for you is getting a small printer by your desk. So your physical workspace. The second bucket is about modifying your schedule. So this could be maybe telecommuting, if that's appropriate. Maybe it's about flex time. So you're still working your regular work hours, but instead of 9 to 5, you work 7 to 3, because that's when you're at your best. And then finally, everything else. So maybe it's about using technology. We've had one person talk about the anxiety that she felt when she went into meetings with her boss because she couldn't participate in the conversation and feel like she could write down everything that was being said and remember it all. So her accommodation was she got to use her iPhone to record every single meeting. so that she had that security blanket when she went back to her desk that she could replay it if she felt like she missed something. It could be about a change in policy. So one example was a gentleman who had a very severe open wound on his forehead. And he wanted to be able to wear a hat in his work environment so that other people didn't have to look at it and it wasn't uncomfortable. His workplace policy said no hats. Well, his accommodation was a change in policy so he could wear a hat. It could be about shifting responsibilities. So legally, we only have to do what are the essential functions of our job. But how many of us in our workplace do more than the essential functions of our job? I know I do. So maybe it's a receptionist who, just because those giant water cooler happens to be next to her desk, she gets asked to change it, and she's suffering from weakness in her limbs. Well, maybe we can shift that responsibility to somebody else. Maybe it's a school teacher who's suffering from fatigue, and instead of having him do recess duty, he can rest during that period and someone else can do recess duty. So kind of shifting responsibilities a little bit. And then finally, the accommodation of last resort is changing jobs for a period of time. This only works if there is a vacant position. So employers don't have to create a new job for you. But if there's a vacant position available and you're qualified for it, maybe you can swap for the time that you need to swap. Now, we hear from a lot of people, both employees and employers, there's this concern about reasonable accommodations, that it's going to cost too much, they're going to be too hard, they're going to be this huge, horrible thing. Well, it turns out an entity called the Job Accommodation Network, which is a fantastic resource, and they're included in the last couple slides here that you have, did a study, and they found that 58% of all accommodations cost the employer absolutely nothing. Think about that woman who had to switch offices. It doesn't cost the employer anything. And then 37% of the accommodations cost the employer a one-time fee of $500. So really, these accommodations don't cost the employer very much, and the benefit to the employer and the employee are huge because the employee gets to do their job and do it well. The employer gets the benefit of all of that. The employer doesn't have to go through all the hassle of finding somebody new, retraining, and all of that. So really, accommodations are beneficial for both sides of this. Couple of practical tips about accommodations. Employers must provide you with a reasonable accommodation if you're eligible, unless they can show that it's an undue hardship. And that's a very high standard for the employer to meet. The trick with all of this is they have to be reasonable. So if you're a grade school teacher, it's probably not going to be reasonable for you to telecommute. Just saying. Also, it's important to remember that you might need more than one accommodation to deal with everything. So I'm sure, as many of you know, rarely do you just have one issue you're dealing with. Oh, I just am dealing with fatigue. No, you could be dealing with anxiety and fatigue and a compromised immune system. So it might be that you need more than one accommodation to really round out the picture. And then finally, we get this question a lot about caregivers. Unfortunately, caregivers are not legally entitled to reasonable accommodations. That being said, remember what I said at the very beginning of this. Many employers are much more generous than what the law requires. So this falls into that category of it can't hurt to ask. But it's important to know that as you go into this, you're not necessarily legally entitled. So this is the process that the EEOC has come up with for how to ask for a reasonable accommodation. And I won't go through all of it, but it is important to know that the process, it has to be a back and forth and a conversation. And if you're thinking about reasonable accommodations, I really recommend accessing the Job Accommodation Network. Okay, taking time off. We're going to talk a little bit about all of these issues, and I'm going to try to do it in 10 minutes, so bear with me. The federal law for taking time off is the Family and Medical Leave Act. The FMLA is a law that is for employees to take time off for their own serious medical condition or to take time off to care for a seriously ill child, parent, or spouse. This comes up at a huge surprise to a lot of people that this definition of family is so narrow. So this means that you're not entitled to take FMLA leave to care for a seriously ill sibling, aunt, grandmother, grandchild, child, parent, or spouse. So it's a very limited definition. Just like with all laws, there are requirements that you have to meet in order to get to use it. You have to work for a big enough employer, which is 50 or more employees. And you have to have worked enough, which means that you've worked a cumulative 12 months for that employer. And in the last 12 months, you've worked at least 1,250 hours. So if you've just started a new job, you aren't going to be eligible for FMLA until you've hit that 1,250 hours. So what does the FMLA get you? It entitles eligible individuals to up to 12 weeks per year of leave. Now that leave can be used in segments, so you don't necessarily have to take all 12 weeks at once. Maybe you just need to take every Thursday and Friday off to deal with days you're not feeling well or doctor's appointments. And we call that intermittent FMLA leave. Now, a couple things about FMLA. It's unpaid. We're going to talk in a minute about how you deal with that. The really, really great thing about FMLA, because I hear from a lot of people, well, I've got sick time, I've got PTO time, I'm just going to take that and not bother with the FMLA. The issue with that is vacation time and sick time is not job protected. So if you're out on vacation, you can be let go if you're an at-will employee. If you are on FMLA leave, it is job protected and you cannot be fired. Unless they can prove they'd fire you otherwise, like they found out you were embezzling from the company or something like that. So that's a really, really important reason why you should be thinking about FMLA if you're taking time off, even if you've got paid time off saved up. It's also health insurance protected, which means while you're out on FMLA, an employer cannot kick you off their health insurance. Really, really important, and I'm going to say it again, and I know I've already talked about it a little bit. Short-term disability, paid time off, vacation time, not job protected. But you can actually use those things with FMLA leave. And the way that it works is, let's say you've got 2 weeks of vacation saved up. You take your 2 weeks of vacation concurrently at the same time with your FMLA leave. And the first 2 weeks of FMLA are paid, and the last 10 weeks are unpaid. But that whole 12 weeks is job protected. Just like with the ADA, there are state leave laws that can be more protective, and I've given you some examples here. Triage Cancer on our website has a chart of state laws where we actually talk about all these different state laws. So if you're curious what's going on in your state, I suggest you check that out. It's just triagecancer.org/state laws, and we update it as frequently as we see changes. Which leads me to disability insurance, and I know I'm going to get a lot of questions, so I'm actually going to ask Mark if I can have 5 more minutes just to go through disability insurance, because I know this is where a lot of questions are going to come in. Lots of confusion about disability insurance. I hear the phrase all the time, I'm out on disability. And that could actually mean a lot of different things. What disability insurance is it's an insurance policy that helps make up the income that you've lost because you're no longer working due to your disability. Policies differ, so they can be anywhere from about 45% to 75% of your monthly income that you were getting when you were working. So you almost never get your full paycheck back. And disability insurance is designed to help you pay for expenses that your paycheck normally goes to. Rent, mortgage, food, gas, those kinds of things. There are different options. So there's private disability insurance policies. So there's ones that you can get through an employer. One example of that is Aflac. You've all seen the Aflac duck. Sometimes employers will pay a part of the premium as an employee benefit. Sometimes they won't. Again, really good thing to look at your specific employer for. Some policies you can go directly to a company like Mass Mutual and say, I want to buy an insurance policy. There are short-term policies and there are long-term policies. The details of these policies will completely differ depending on the policy. So even from one company, you might have two short-term disability policies that are totally different. There are also a handful of states that have state disability programs. And then finally, there are two federal programs. Both programs are run through the Social Security Administration, and both programs are long-term policies. Both programs have the same definition of disability, which is that you can no longer do your job due to your disability. You cannot adjust to a new job, and your disability is expected to last for a year or longer or result in death. This is a very, very strict definition, and a lot of people get hung up on the second component of this in terms of can you do a new job? So I'm trained as an attorney. If I have a disability, which means I can no longer be an attorney, but I can bag groceries at the grocery store, the Social Security Administration is going to say you're not disabled. Okay, SSDI, Social Security Disability Insurance, is the first program I'm going to talk about. This is based on having worked and paid into the system. Most of us in this country, when we work, we pay Social Security taxes, and a portion of that goes into this program. How much you receive when you're on SSDI is based on how much you've paid into the system. So somebody who consistently makes $200,000 a year will get more from their SSDI than someone who's made $45,000 a year. With SSDI, there is a 5-month waiting period before you ever get a check. This comes as a surprise to a lot of people. The rationale, I'm not saying it's a good one, but the rationale is it's the Social Security Administration's way of making sure that the disability is in fact a long-term disability. Once somebody is receiving SSDI for 2 years, they then become eligible for Medicare, which is one of two federal government health insurance programs. The second federal program is Supplemental Security Income, or SSI. And unlike SSDI, this is based on having a low income and asset level and falling into one of these other categories. Unlike SSDI, there's no 5-month waiting period. And if eligible for SSI, generally you're going to be eligible for Medicaid in your state, which is the other federal health insurance program. So some important differences between the two programs. Now, in 2008, the Social Security Administration started this program called the Compassionate Allowances Program. And it's a list of certain medical conditions that are presumptively eligible for SSDI. It doesn't mean that if you have a condition that's on this list, you're automatically going to get SSDI. It just sort of makes it a little bit easier to do so. If you're thinking about SSDI or SSI, I strongly encourage you to chat with your healthcare team. They can be an invaluable resource in this whole program. And I suggest that you apply as soon as you need it. Because remember, the Social Security Administration is not a speedy entity. And on top of that, you have this 5-month waiting period. So if you wait until your disability is gone a whole year, you're doing yourself a disservice. Now, this is a very conservative number in terms of the number of applications that are denied. I've seen numbers as high as 75% of applications are denied on the first try. And I tell you this not to be discouraging or Debbie Downer, But just to tell you to be prepared for it, so that if you get that initial denial, be prepared for it. There are 4 levels of appeal, and as you go through the levels of appeal, the percentage of approvals skyrockets. So even from initial application to request for reconsideration, there's a huge jump in numbers. As I mentioned, Cancer and Careers is a wonderful partner and a great resource. They have all kinds of free resources on their website. If you're looking for a job, they've got a free resume review service that I recommend you look at. We do lots of webinars with them. We also have an annual conference here in Chicago that we just had. We'll have it again next April. And then when you're looking for a new job, all of the things we've talked about today are relevant. So I know I talk sometimes about if you're currently in a job, but the ADA, remember, protects you even before you've gotten the job. Talk very quickly, and we're going to go into some questions now. But please know that Triage Cancer can be a resource for you. We have a plethora of online resources available. There's an orange sheet in the back called a quick guide to disability insurance. We put these quick guides out on a variety of different topics. They're not designed to be comprehensive and give you every piece of information about a topic, but rather they're designed to be sort of a quick introduction for you, a starting place, and then we hope that you can find more resources on our website about the topics. So with that.
Perfect timing. Thank you so much, Ms. Fawzi Bryant. We appreciate it.
Thank you.
We're ready for questions now. What we're going to do is raise your hand, and our volunteer will hand the microphone to you. That'll save a little time and make it easier for those of you who are inside. So please.
Just to make a comment, my wife is on Social Security disability. There are many cancers, leukemias, which qualify for the expedited approval. We went in, and a week and a half later, she was approved. Not only that, they moved her date of disability back 5 months.
Yep.
So if you're and this was all done through our provider. They sent the information to SSDI, Social Security, and when we got there, my wife was a mess. I mean, she was a mess. And they were very nice, and they just filled out the stuff and said, well, you'll let you know in a couple of weeks. And a week and a half later, they said you are, and everything went very nice. If you've got, with Social Security, a lot of it is, if you are really, really in bad shape, they are nice.
Well, I'm delighted to hear a happy story for once. I rarely get to hear those. Yes, there are about 60 different cancer diagnoses on that compassionate allowances list I mentioned. So that's definitely great, and I'm delighted to hear that the healthcare team was so helpful.
Yeah, it was great.
Always happy to hear happy stories.
I have a question about the SSI denials.
Yes.
Now, do you necessarily have to get an attorney if he's denied, or
Great
can
question.
we go above in front of the panel ourselves?
Very good question. There's no requirement that you have to have an attorney, and I'm just going to go back quickly. Here are the 4 levels of appeal. For the request for reconsideration, that's done through paperwork. So the SSDI will come back and say you've been denied and kind of give you a reason. So maybe it's you didn't provide enough documentation. For that level, I would say talk with your healthcare team, see if they can help you get more documentation together, and then submit it. When you start getting higher up, like for the administrative law judge or the appeals counsel, your chances of success are higher with an attorney. And the reason for that is it's a very small community that does this. And so all of the attorneys know each other, all of the judges know each other, the judges know the attorneys. So if you were just to go in there by yourself, you're at a disadvantage. Now, I will say this. You might be thinking, I'm not working. How am I going to pay for an attorney? The great thing about this system is it's all based on contingencies. So when you find a Social Security disability attorney, they don't actually get any money unless they win your case. And then they get a percentage of whatever the back pay is. And I wish I could remember this. I think it's 25% up to $6,000, but they can't get more than that. So it's one of those things where it doesn't really hurt you to get the attorney, because if you don't win, you're in exactly the same boat that you were in. And if you do win, at least you've gotten something out of the back pay. So I will also say there's agencies, and ALSUP, ALLSUP, is a wonderful resource that can help you through the disability appeals process. So those are two good resources that I would recommend. But if you've gotten past this request for reconsideration, I would strongly encourage you to think about getting an attorney. We've got one in the back.
My question is about FMLA.
Yes.
The 1,250 hours.
Yes.
So my situation, I was working for the federal government, Department of Defense, for 3 years. And I left to do a postdoc. And I just finished my postdoc, and now I'm working for the federal government again as of this past March.
Okay.
Do the time before, does that count towards the 1,250 hours, or?
Yes. So here's the tricky thing about FMLA. You have to work for 12 months, but that 12 months has to be cumulative. So you're allowed to look back 7 years and count up all the time you worked for an employer to get to that 12 months. The 1,250 hours is in the last 12 months you've worked for them. Have you worked 1,250 hours? So you get to look back 12 months and see how long you've worked for them and count up to that 1,250 hours. But I would say go to the benefits person and talk to them and say, if you were to calculate my FMLA time, how many hours would I have? And start with that. For you, it's only hours that you physically worked that are going to count. So you can't count vacation time that you may have taken in that time period or travel time. I'm assuming, were you on military leave?
No.
Okay, so other Department of Defense. Okay, all right, just checking, because the military has all sorts of other roles. So it can be a little bit tricky, but I would start with, can you tell me what my hours would be? And then calculate them yourself, and if there's a discrepancy, have a conversation. Hope that's helpful.
Yes.
Okay.
Hi, thank you. I have 2 questions. One is, how does SSDI work with private long-term disability plans? And then the second part is, how would you advise somebody if their employer might be wanting to discuss a change in your job, both in terms of responsibilities and perhaps title? And, and this is in the state of California and not FMLA.
Okay, so I'm going to start with your first question, and then I might ask you to repeat the second one. So most private long-term disability policies will require you to also apply for SSDI. And then if you become eligible for SSDI, they will deduct the amount that you get from SSDI out of what they were paying you. So let's say, for example, that private policy pays you 70% of your monthly income. You apply for SSDI, SSDI pays you 50% of your monthly income. Well, you don't end up with 120% of your monthly income. What you end up with is 50% coming from SSDI and 20% coming from the private policy. Does that make sense? Okay. It is very common for private policies to require that you apply for SSDI. Okay. Second question. Your employer wants you to, and correct me if I'm misstating this, your employer wants to discuss change in role, change in responsibilities. And is this as a result of you disclosing anything?
Yes. I mean, there is a workplace accommodation in place.
Okay.
That entails like schedule adjustments. Some job responsibility shifts because of reduced time.
Okay.
Working,
Okay. So you can't be demoted for asking for an accommodation. But you do have to still be able to do the essential functions of the job. So let's say, for example, you're a manager, and the essential functions of your job is overseeing 10 employees. Well, now because of your accommodation, you can't oversee those 10 employees, then there might need to be a change. So, I mean, that's the part of all of this, is that you still have to be able to perform your essential functions of your job with or without those reasonable accommodations. So it's a little bit tricky when you're, just asked to come in for a meeting to have this discussion. Cancer and Careers actually has a great suggestion and technique about this in terms of practicing the conversation before you go in. So get a friend to help you, a family member, and kind of role play how you think the conversation might go, and have some answers in your head about how you might respond to certain things. So if your employer says, I think we want to change your job title to this, how would you respond to that? And maybe it's just about how will you carefully say, I need some time to think about that. And having those sort of canned responses can be really useful in making sure you don't accidentally say something in the moment, like, okay, that sounds good, because you don't know what else to say, because that happens, right? When you're asked a question, when someone's tells you something and then there's silence, we tend to fill silence. So that would kind of, without more details and more information, that would kind of be my suggestion, is see if you can role play the conversation and have some answers in hand, and then know that you don't necessarily have to respond in that exact moment, and just that you're entitled to some time to think about how you want to respond to that. It might be that these changes are beneficial to you. I don't know.
Is it reasonable to ask for legal guidance, for the employer to help you with legal guidance on it? Because, in other words, it's a little beyond all of our knowledge.
Right.
And
right. So I would say it depends on the job, it depends on the employer, and I would say the only thing to think about that is the employer in a position to really tell you what your legal rights are? I don't know. If you work at a law firm, maybe. And also remember, when you're talking to HR isn't just there to protect you. They're there to protect the employer, too. They have that dual role. So it might be useful for you to even say, thank you so much. I just need some time to digest this and get a little bit more guidance. And you don't even need to see legal. Just say, get a little bit more guidance before I respond. But can I give you a response in X amount of time? And frankly, most employers should be reasonable about that. You're welcome.
Hi. I have been told once you go through a bone marrow transplant, I've got multiple myeloma, so it's terminal, not it's terminal. But, so I've heard that SSDI will automatically approve you once you go through the first transplant, and then if I got sick now where I needed to go on it, it would be a very, very gray area. It's not automatically approved.
So I hesitate to say that anything is automatically approved by the Social Security Administration. The word automatically is very concerning to me. I know you had a fantastic experience, but I travel all over the country and I hear some not so fantastic experiences.
I've read the code of federal regulations, and it is.
So there's nothing automatic about it. You still have to show that you have a disability.
Oh, yes.
You still have to meet these requirements. Now, if something were to happen post, you've been on it, you've gotten off of it, something else happens, you need to go on it again, you do have to start the process all over. You have to do the initial application, you still have to submit all the paperwork, and if you can show that you have a disability with that documentation, you should, again, I hate to say you should be fine because 65% are denied. But you are starting the process over. It's not like you get to go to a different line because you've been on it before.
So then you can go off and go back on.
If you meet the requirements. But it can be, again, especially if it's a new disability. So it depends on what is going on with you. Now, the Social Security Administration has multiple programs to help individuals get back to work. So there are programs where you can actually go back to work for a certain amount of time and make a certain amount of money and still get your SSDI benefits and still maintain your Medicare. So it's a return to work program. They actually call them work incentives. And because the whole goal is if you're healthy enough, let's try to get you back to work. It's not always possible for some people. Some people will be on it forever, and that's appropriate for some people. But there are programs to help you that are designed to help you return to work. And again, those are called work incentives. And if you go to ssa.gov and you type work incentives in the search box, it gives you a lot of information about the various programs.
At what percentage do they continue to pay for you?
Oh, it's so early for numbers. So
This is a very important issue.
it is a very important issue, and I can look it up for you to get the exact numbers. I hesitate. It changes all the time. So it's somewhere in the $2,000 to $3,000 a month range that you can earn and still be eligible. I'd have to look it up, to be honest.
Yeah.
So I'm terrible with numbers, which is why I became a lawyer. So keeping them in my head is a little challenging. But I can certainly, it's on the website. You could look it up very easily.
What website is that at?
Social Security Administration, SSA.gov. So it's about how much you can earn at a job and still keep your SSDI benefits. But you have to be part of these programs. So you can't just say, I'm on SSDI, I'm going to go back to work. I'm not earning enough, I should be fine. So if you're thinking about going back to work, but you're concerned about losing your SSDI benefits, I strongly recommend that you contact the Social Security Administration and let them know what you're thinking about and have the conversation with them. Especially if you're getting health insurance benefits through Medicare or Medicaid, because you want to make sure you can keep those benefits if you're not sure you're going to stay at work.
Okay, I have a 3-part question, so I can either.
Okay.
Sorry,
No, that's okay. I'm preparing myself.
It's all intermingled. So,
Okay.
Hypothetically, all right. So on Thursday, my husband lost his job. He was an employee at will in Illinois with 14 employees, so he has that one protection, but not the other.
Right.
He has a separation agreement we have not signed yet. The first question would be, should he sign that without having an attorney review it? Because otherwise he wouldn't be eligible for his severance. And the second part is, can he go ahead and apply for unemployment if he's also going to apply for SSDI?
Very good question. Okay.
And the third part is, if he was demoted several months beforehand and took a pay cut, is there any recourse now, listening to what you're talking about, was that they knew he had a disability. He's battled it for 3.5 years. It's very public. So is there any recourse for him now because he took an enormous pay cut?
Okay. First question, should you sign the severance agreement without an attorney? I can't answer that for you.
Okay.
So I would say if you have read it and you're a little bit concerned about how this employer has been acting and you feel uncomfortable about signing it, it might be definitely worth your while to have an attorney take a look at it.
Is there someone who does that at no charge?
No. Well, maybe. So you could try to go to the legal aid entity in your community, which I don't know off the top of your head in your particular community. In Chicago, there's a few. The Chicago Bar Association has one. Eligibility is usually based on income, so depending on what your household income is, you may or may not be eligible. But you could certainly try. Give them a phone call, say, this is my situation, would you help me review it? It's really tricky because you have to look at what are they saying in return for the severance, what are they requiring of you? I just read one for a friend, and they were saying like she couldn't work in her profession for 2 years in the city of Chicago, and she's like, it's not worth the $5,000 that they're offering me for that. So that's something I can't answer for you. The second question, which I've now already forgotten. Yes, unemployment and social. Okay, the very easy answer to that is no. So here's why. When you apply for unemployment, you're basically certifying to the state that you're looking for a new job. When you're applying to the Social Security Administration, you're very clearly stating, I cannot work because of my disability. So you are at a fork in the road, and you have to decide which path you're going to take.
But I've heard of people who've gotten unemployment while waiting for disability.
You're signing a legal document to both entities saying two polar opposite things. So has it happened? I'm sure.
Can you wait till your SS, and then you have a 5-month waiting period? So, okay.
Yeah. it's a tricky situation.
And is there any recourse now about the demotion?
Maybe. Here's the hardest thing about discrimination lawsuits. Can you prove it? Can you prove that the demotion was as a result of their knowledge of the disability? We've had situations, there was a woman who contacted us and said, I have a voicemail recording of my employer saying we're going to have to let you go because of your cancer diagnosis. We call it the smoking voicemail. But rarely are employers that. Thank you for not making me say it.
I guess because anything can be painted under the guise of you. Because, I mean, it's this gray area. Because of your disability, your cancer, your treatment, you're not able to maybe do all the elements of your job that are required. But at the same time, you can't do your job, so they better reclassify your job. I mean, it seems like this.
It isn't, it isn't. So that's why if you look at the slide where I talk about when do you ask for reasonable accommodations, you should ask for it as soon as you think you might need it. And it's for exactly this reason. Because if you go in and ask for that reasonable accommodation, that should help you be able to do your job, and it makes it much harder for employers to demote you, to change your jobs without it being part of your reasonable accommodation. If you wait in this, I'm going to try to stick it out and work it through, then you can be demoted based on job performance. And that's a really tricky thing. So for people who are in that gray area of like, I don't know if I should ask for reasonable accommodation, I'm not quite sure, we usually say, you should probably think about asking for that reasonable accommodation because it puts the employer on notice that you have this disability, and it makes it much harder to make decisions than if you're in a situation where it's like, well, you were this stellar employer, and now you're not this stellar employer, we're going to demote you. So, I mean, certainly I would say if you are feeling like you want to sue, there are ways to go about that, and I can point you to how you can find an attorney. But I also say to folks, it's usually a very long, drawn-out process. The employers usually have more resources, so it's just about figuring out where you want to put your time and your energies to. And I'm not discouraging you. There are some cases that are very worthy, and the reason we have these laws is because people did go to court. But it's hard. It's hard to prove. It's really hard to prove. So, sorry, it's not a good answer.
No, that was the answer I needed, so thank you.
Yeah.
I wish we would have had you 6 months ago.
Hi, I've got several questions. I'm just going to do them one at a time so you don't
thank
lose
you.
track of my questions. Some of them are pretty quick. Diagnosis on FMLA. I recently, for the first time, I'm a social worker. I've been doing these for years. I had one sent back and said they needed a diagnosis. I had thought that was illegal. I didn't think you had to put the diagnosis on. I always just put serious medical condition, and then I described the condition just in case. Mm-hmm. So I called the patient, and I said, look, they want this. We can do it one of two ways. I think this is illegal. I can call you, we can talk, or I can just do it so you can get it. He was okay with the diagnosis being on there, so I didn't. But that was one question.
Okay, so let me answer that because it's a fantastic question, and it goes back to that disclosure piece. So medical certification, for those of you that don't know, employers are absolutely entitled to a medical certification if you're asking for a reasonable accommodation or if you're asking for medical leave. Because if you think about it, it's fair for the employer to know that you're in fact entitled to these things. But the employer's only entitled to so much information, and a diagnosis is not part of that. Especially because a lot of the times with cancer, it's not the diagnosis itself that gives rise to the disability. It's the side effects from treatment. And for some people, they don't want to disclose the diagnosis. So the unfortunate reality, even though a diagnosis is not required on these forms, employers create their own forms. And we are very much a society of we see a blank line, we fill out the blank line. You get the gold star of the day for even recognizing that, hey, this might be an issue and having the conversation. What we've had some healthcare professionals do and what we are talking about as we go around the country and talk about this is the Department of Labor has a model medical certification form. And we've had some people in that situation, instead of filling out the employer form, fill out the model certification form. And then the employee takes that back and says, this is what my healthcare team gave me. Most employers are not going to say, I'm not going to accept the Department of Labor form. That's just the case. We've also had some healthcare entities make it their policy that they're only going to fill out the Department of Labor form. Like, we don't care if your employer gives us one. The only form we fill out is this Department of Labor. And we've yet to hear an issue with that. So,
I'll tell you, this was the state of Indiana, and they used the Department of Labor form.
Well, there's no diagnosis on the Department of Labor form.
No, it says serious medical, but they wanted me to put the diagnosis on it. So apparently
they can want all they want.
No, I didn't. Okay, so that's one question.
Yeah, I mean, they can want all they want, but you don't.
Okay, so
there
that's
should
one
be
question.
no form. I do just also, okay, go ahead.
I'll just ask this one. This one's been a question for common law spouses. You mentioned that as being able to get FMLA. Is that do all states recognize common law? Okay.
Please don't ask me which states right now. I'd have to go back like a decade to law school to get you each state. But no, not all states recognize it.
Okay.
Yes, I have a question.
One more.
About the number of employees and the laws of various states. For example, say the employer is incorporated in Ohio, the company is domiciled in California, the employee works in Illinois. So in terms of number of employees to come under the protection and the various state laws, what rules?
It depends on the law. So, if we're talking about FMLA, I lost the slide, the requirement is that the employer has to have 50 employees within a 75-mile radius. So that's 75-mile radius. If we're talking about state fair employment laws, it's generally going to be the state in which the majority of the company operates. So if they're just registered in Delaware, but everybody's working in Illinois, it's going to be Illinois law. So it can get much more complicated than that, which I don't have in the 3 minutes to talk about. But if you have a specific example, later that you want to talk about, we can talk about it. But that's generally speaking how it works. It's also a little bit tricky for people who don't have a fixed workplace. So like a commercial truck driver who's all over the country. That for, let's say, FMLA is going to specifically be where the person goes and picks up their paycheck, or would go if they were going to have a meeting with their supervisors. So it's that work site. So yeah, I mean, I'm certainly giving you the high-level answer here, but it can get a little complicated. There was one more? Hi, sorry.
Mine is in reference to yours because I was unaware of this. My son has multiple myeloma, but he also was born with several learning disabilities, cognitive issues, but he has always lived on the positive side of life, has worked and worked for Target for 14 years at the distribution center unloading trucks before he got his cancer diagnosis, and so was, to me, very successful because he's a hard worker with a lot of ethic. And then he got a new boss, and we are technically, we don't know for sure if it's because of the new boss that doesn't like people that are different because he's very hard to understand. He loses some of the directions given to him, but it was a very simple job, so he didn't have any trouble with it. He was fired from the job.
Okay.
And now I have noticed there's several things that are different, that are more, I guess you would say, pronounced since the cancer and since the chemo and stuff. And so we're looking into that cognitive issue, the chemo brain they talk about.
Right.
So that's a question also. But we applied for unemployment for him, so he has some income, but we also applied for SSDI at the recommendation of many people that have known him for a long time, including some social workers that wanted me to do it a long time ago. And we didn't want to go that route because he wants to be independent. So now we have applied for both of those things. So you're saying that we should stop the unemployment process now because we've started the SSDI process, and the people we talked to at Social Security said that they didn't see that there was going to be a problem because he has multiple issues.
So if the Social Security Administration, here's the tricky part. You don't want the SSDI denial because they're saying, well, he's getting unemployment, so he's looking for a job, so clearly he can work.
Right.
That's where it gets to be a problem.
But he can't get the unemployment, which I think Target owes him, unless he goes. And so right now we're playing a game of cat and mouse, trying to find jobs that he can apply for that technically we know they're not going to, it's not like he's applying to be a lawyer, but he's applying for things that he probably would not get because of his speech and language barriers. And so we're trying to play the game without, we don't want any deception or any lying, so we're trying to be honest on
So
both
here's the
sides.
thing. Unemployment is not a forever thing, right? It's time limited.
Right.
So one option is you exhaust the unemployment as you're looking for jobs that might, and it might be that you find a job that you can do and that you want to do, and you go that route. If unemployment is exhausted and you can't find a job, well, then maybe the SSDI route is the route to go.
Well, the SSDI is already in process.
I would
also,
say you don't withdraw the application at this point, but be aware that it might get denied.
because of the unemployment.
Well, it might get denied because 65% of applications get denied, but it could also get denied because of that unemployment piece. Because remember what you're saying for unemployment. You're saying, I'm looking for a job, help me make ends meet as I'm looking for a new job. SSDI is, I have this severe disability, which means I cannot do a job. They are not, they don't work together.
That he could work with the SSDI, he could work and make up to $1,000
Yes,
a month.
it's substantial gainful activity. So yes, that's absolutely possible. You can work up to a certain amount.
So if he gets a job that is part-time while we're waiting for the SSDI, that really shouldn't affect that.
Correct.
I mean, it just seems like one's working against the other.
I know.
It sounds like maybe you wait until like 3 or 4 months into your SSDI. I can't get a job. I'm trying so hard.
Through your unemployment.
Yeah. So your unemployment. Now maybe I'll switch it and just have a lapse.
But the SSDI, if you get knocked out of that date, they have to start over again and have a new date, and then you're starting that 5-month process all over again. That's what I understood.
I'd like to thank Ms. Fawzi Bryant. I'd like to thank you all for wonderful questions and great attention. Thank you so much. And I'm sure she'll be here for a few minutes to take some individual questions.